Hello, this is Matt on the Moon Lambeau channel. Just several days ago, there were two amicus briefs filed by parties that we had no idea would end up attempting to have influence on the SEC v. Ripple case. One was from a company called iRemit, which is a customer of Ripple's, utilizing on-demand liquidity, which means literally using on a daily basis XRP as a bridge currency. They shared their perspective in this amicus brief, and technically, they have to go through an application process, which is sending in the information to the judge saying, hey, we want to file this. And there's an actual copy of what the brief is. So the judge gets it regardless. It's just a question of whether or not it's going to actually be a part of the SEC v. Ripple lawsuit. And then there was also TapJets, which is a firm that's using XRP as a form of payment to get around what they called the Friday nights problem. Because in terms of private chartering of jets, it's a very expensive world. And that's what this company is in, TapJets. And if you want a private jet, you got to pay for the damn thing up front. Now, the problem with that is the movement of money in the legacy financial system, a little slow. It's not, and also it's done during business hours. If you want to send a wire transfer to pay for your flight, which could be, in the continental U.S., it's typically about $60,000. TapJet stated for transatlantic flights, they stated it could be in the hundreds of thousands of dollars. That would be very normal. And if you want to be able to just on a whim, go ahead and get a flight, well, TapJets is the answer. They're the only company on the planet doing what they're doing. That's what they've effectively stated anyway. They're basically Uber, but for private jets. And so while banks shut down and you can't pay for flights that you may want, after business hours and on the weekends, sorry if you didn't plan ahead of time, you just don't get your private jet. I know, boohoo, right? But still, today, I'm just pointing out there's a real use case here. But with XRP flowing 24/7, 365 and having real world value because humans decided it's worth something, well, that solves what they call in that industry the Friday night problem. And so there were these amicus briefs filed, and yesterday the SEC filed a brief, wrote a letter to the judge, said, here's why these amicus briefs from these two parties should not be considered. They should not be a part of this case. Now, I already covered that in a video, like I said, literally yesterday, so I'm not going to touch on that. But Ripple's attorneys, they filed a new legal brief responding to what the SEC said. And my gosh, I tell you, these SEC attorneys, like these little bitches, Ripple, they just gave them a smackdown. And they wrote to the judge, and I'll give you the full context of all this, but they stated that effectively, based on what the SEC has wrote, they potentially had no business bringing the litigation that they brought in the first place. And I'll give you the full context and details of that. But upon reading that, it was just one of those moments where I was like, wow. And that's how they ended the brief. And it's just it stuck with me. And so many people anyway, in the community read that, and it's just like, whoa. It's one of those moments where it's this is one of the most strongly worded things. And it makes sense too. So I think that's going to probably stick with the judge. So I'm going to share with you what a couple attorneys within the XRP community had to say, including attorney John Deaton. Then I'll run through just a couple key spots that I enjoyed the very most of this thing. So I printed it up, just 2 pages here, so didn't slaughter that many trees today. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. A shout out and credit to XRP community member and attorney James K. Filan for sharing this document, as well as attorney John Deaton's crypto law. And so here's what attorney John Deaton had to say about this. And he tagged Gary Gensler, the SEC Enforcement Director Twitter account, the SEC Twitter account, and Allison Heron Lee. And so she was, I guess she's no longer, that's right, I was thinking that as I was reading this. She was a commissioner, and apparently she voted in favor of bringing the lawsuit against Ripple, out. That's a weird way to word it. That is not what I meant to say. But she voted in favor of suing Ripple. There you go. That's the one. Hashtag nailed it. But anyway, she's no longer a commissioner at the SEC. So John Deaton tagged her as well, and he wrote the following. So he tagged all them and said, and any other person that supported this lawsuit or supports the nonsense spewing out of the mouths of SEC enforcement lawyers should be ashamed of themselves. There is no need for the SEC to object to something that everyone knows is true. XRP is accepted as a form of payment for thousands of vendors and businesses. It doesn't make XRP special because so is Doge, SHIB, Bitcoin, ETH, etc. This is not a contested matter. Tapjet said one of the crypto assets it accepts is XRP, and the SEC runs to the judge claiming they don't have an opportunity to check and see if that is true. It's disgusting. Time Magazine accepts XRP. So what? Why would the SEC try and hide something that everyone knows is true? I'll bring up staking and being able to collateralize your XRP to obtain a financial benefit independent from Ripple, a benefit from the token itself. Everyone knows this to be true. But watch the SEC act like they don't know if that's true when they reply to my brief. The fact that SEC Enforcement Director allows his attorneys to argue things they know they lack a good faith basis to argue is pathetic. But then again, I guess the SEC has backed itself in a corner because it is fact arguing that when Time Magazine accepts XRP for payment, Time Magazine acquired an unregistered security. Desperate theories require desperate actions. And it does seem desperate. And so that's a little taste, especially for anybody that may have missed the video or the topic in general yesterday when the SEC filed that legal brief making these ridiculous, completely absurd claims. John Deaton's responding to a bit of it again right here, frankly. I mean, the idea, because that's part of what they asserted, is that there's all these claims out here, and one of the many BS things that they asserted is that, oh my gosh, this is what was being discussed effectively, right? Like we got to do all the research. How are we even to respond to this? That's effectively the angle they were coming from. But you'll see as we go a little bit further into this video why that's the stupidest damn argument you could possibly argue on this. Attorney Bill, member of the XRP community, shared this thought in reaction to this legal brief from Ripple's attorneys. He wrote, "Thanks, James. I love the last point from Ripple's attorneys you quoted, but Ripple does not answer the assertion that it could have adduced this evidence but didn't. I suspect it didn't for both tactical and commercial reasons." Yeah, so I'll say that's a perfectly reasonable thing to observe. And I had a little bit more time to think about this because Attorney Bill was talking about this idea yesterday, which again is totally reasonable, thoughtful conversation. And part of it could be that, look, I'm just coming to realize there are probably like way more businesses utilizing XRP that we don't even know exist. Companies that are just out there doing their own thing. And I'm sitting here thinking, how could Ripple know to go to all of them? Like Ripple can't know all of the companies on the entire planet that are utilizing XRP. Did they know about TapJets? I don't know. I have no indication one way or another. Now, as far as iRemit goes, okay, sure. But even when it comes to that, like, was Ripple supposed to go to all of their customers and like pester them for an amicus brief? Their customers. So I don't know. I don't have the answer for that. I'm glad that iRemit filed what they filed. I'm glad TapJets did too. Perfectly reasonable thing for Bill to bring up, but I don't know. I don't feel like Ripple did a horrendous wrong. And who knows? We're not privy to all of their big picture strategy. Yes, we see that they're going with the pretty strong argument that, there's no contract here, which means there can be no investment contract, which means we can't even be talking about how that sounds pretty powerful. But we don't know all the intricacies of what they're going to argue moving forward if necessary. Yes, there was the motion for summary judgment, but who knows? What if there actually is a jury trial? Not that I'm anticipating that, but what if? And so let me share with you a couple parts from this thing. I highlighted just what I found to be the most interesting portions. And this was written to Judge Torres. And it reads in part as follows. The SEC mischaracterizes both the briefs and the law when it claims that the proffered amicus briefs of iRemit and TapJets, quote, constitute improper attempts by movements to offer evidence outside the constraints of discovery restrictions, the rules of evidence, and this court's prior order, end quote. iRemit and TapJets are independent third parties, otherwise unconnected with this litigation. They seek permission to file briefs to offer the court their important perspective on whether industry participants invested in XRP, whether they expected profits from defendants' efforts, and how the SEC's theory of this case, if adopted by the court, would adversely impact their businesses. They provide the court with information concerning their business operations and industries to support their perspectives. There is nothing wrong with that. Indeed, the main purpose of amicus briefs is not to repeat legal arguments made by the parties, but to provide the court with a broader industry perspective. So there you go. And again, that's what I was saying. Like, I don't think you could necessarily go to every single firm on the entire planet and get their perspectives, nor should they necessarily be hassling customers here. So the fact that these firms did, I'm not going to dock Ripple a point personally for them not having reached out to these firms and said, hey, could you file a little amicus brief for us? You know, if you have to exert time and energy, it's better if it's just organic anyway, frankly. That's just my humble opinion. And now go to page 2, and this is the best part. This is the money shot right here. Reads as follows. It's the last paragraph. Here, highlight the first word for those of you looking at the screen. Finally, the SEC remarkably suggests that it would be prejudiced by its inability to, quote, evaluate the factual veracity of their claims or show that movement's facts are disputed, end quote. So pause. The SEC saying that they can't evaluate what these what's included in these amicus briefs from iRemit and TapJets. They can't evaluate this stuff and speak to the factual nature or lack thereof regarding the contents of that. They're actually arguing that, and this is why what Ripple says at the end of this brief is so freaking money. Their attorneys write, the SEC has sought summary judgment based on what it erroneously claims are undisputed facts that every purchase of XRP is an investment, and that every XRP purchaser expects profits from Ripple's efforts. Nothing could be more to the point that these two amicus briefs refuting, or at least disputing, both points. If the SEC cannot evaluate the veracity of such claims, then it had no business bringing this litigation in the first place. Mic drop, biatches. I love that so much. Think about this. Because what iRemit and TapJets is arguing flies in the face of what the SEC is arguing. That's why they don't want it to be admitted in any capacity in this case. They don't want this to be a part of the case. Of course they don't. Because these asshats at the SEC are little baby back barrel trials, and they can't, in good faith, argue these points. They're wrong on the facts and circumstances, period. And so to see this, it's just Ripple's just like, yeah, come on. You know, they're just looking at this like this is completely redonkulous. My gosh, and it is true. They had no business bringing this lawsuit in the first place. They can't respond to this, or this is inappropriate. And by the way, and I didn't get into some of the nitty gritty in terms of like why the two companies that filed the amicus briefs did it within the rules of the court. It seemed a little bit dry. It's on your screen if you want to read this stuff. It's in particular this paragraph right here that I'm highlighting. But Ripple says that they're wrong on those facts too. So I thought I'd just mention that at least. But other than that, I'll go ahead and wrap up here, and you let me know what you think below. But I rather enjoyed that. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.